Well, hello and welcome back to my channel. My name is Joanne. I'm a law student. Hello, Christine. How are you? I just wanted to give you an update. So I've found out that there was new filings. So I am just grabbing them at the moment. Now, the interesting thing is that we'll just have a look at all of these. We're just going to have a look at all of these. So I'm just opening up all the pages now. So we will try and deconstruct and work out what on earth is going on here with all of this stuff, because there's quite a bit to get through, which is a bit scary actually, when we think about it. So we're going to have a look at this. So let's have a look at what is online at the moment. So let's start here and try and deconstruct it all, because it's right. So we've got here. Are you were wondering what was happening? Yeah. So here is the action. So just to bear in mind, we've got the plaintiffs, which is 7M and the Derricks and Shin, and the defendant is KJ and Without a Crystal Ball. Okay. So we had the notice of motion. Hello, Grace Lee. We've had the memorandum. We've had the affidavit. We had the notice of motion. Yep. So, and then on the 3rd of the 9th, so on the 21st of the 8th was a proposed order. Now, let me find this proposed order, because this was really interesting when I saw this. And I sat on it for a little bit because I really wasn't sure what to make of it initially. Now, is this the one that was proposed order? So I'm just going to click on this one, because this is really interesting. Okay, let's open this up, because I want to have a look at this, because this is what is really interesting. Christine said the trash bag. Yes. Oh, hello, Harrison. Okay, so this was Katie Joy's order. Hang on. So is that document number 167? So yeah, it's a little bit messy at the moment, because I'm just trying to work out which document was which. Okay. I might have to go and find Miss Balls. Actually has a really good summary on her page. Hello, Keto. Hello, Grace. So has it all. So let me just, I think it might be easy I tried to open it all up one at a time. It's just got really confusing, because it's not telling me. So this is what Miss Balls has said. Okay, Miss Balls showed that this was really interesting. Okay, all right. So Miss Balls pointed. So this was filed on the 21st of August. This was Katie Joy's proposed order. It says the above was. So she says defendant's motion for reconsider the courts on January 23, 2025 is granted, and defendant's motion for summary judgment is granted on all counts. Now, remember, I said the defendants is Katie Joy. Okay. Oh, yeah. Sorry. That was the correction. This was the one filed in August. Said that the plaintiff's motion for summary judgment is counted. You see, if you're thinking that you're confused, the lawyers are also getting very, very confused because they've had to do a correction to their document because they got confused as to what it is. So this is what was filed on the 21st of August. Defendant's motion to reconsider the courts and the plaintiff's motion for summary judgment. Now, if we go back to the tab here, we find the plaintiff is the 7M and stuff. So that was on the 21st of August, okay? And then on the 3rd of September, they've had to do a recorrection because it was wrong. So on the 3rd of September, they filed this one, which is the correction. Okay, so if you're feeling very confused, okay, bear in mind, it looks like the lawyers are getting confused too. All right, so don't feel bad if you are feeling confused. Okay, so just bear that in mind because everyone's getting confused here, okay? All right. So now we've got what's been filed is a proposed, so that was the 21st, proposed order, so that was fixed. We've now got a responsive motion filed on the 5th, an affidavit, and another order. So this is yeah, I know, it's very confusing, right? As I said, if you're feeling confused, don't worry because it would seem that the lawyers are too. So we're going to just zoom in. This is 10 pages, okay? So we've got 10 pages here. Let's see. So this is their opposition. This is their in opposition to what's gone on, okay? All right. So this is filed by 7M and their lawyers, and so this is filed by the plaintiffs, okay? Now, I can already see something very, very interesting. The first word of the introduction points out that the defendants did a 23-page memorandum, okay? So it says, introduction, defendants 23-page memorandum in support of her motion for reconsideration fails to mention a single item in the court's June 23, 2025 order on parties' cross motions for summary judgment, which are erroneous. Defendants have not brought a motion for reconsideration, but attempting to grandstand in and introduce new evidence while getting a second chance at their motion for summary judgment. This is an improper use of a motion for reconsideration, and the plaintiffs should be granted attorney costs and cost for defendants' unfound motion. So they're going in hard here. Now, if you remember, when we read Katie's stuff, she mentioned that there were raids on Shin's house, which I said at the time was new evidence. And if you are doing a reconsideration, you cannot bring in new evidence. You have to rely on the evidence already before the court. So this is their argument, that they're relying on new evidence, which is not before the court. And they're also stating straight on the outset that this is a waste of time, and therefore Katie should have to pay the attorney fees for this waste of time. Okay? Straight off the bat. So they're going for attorney's fees. They want this to be stated. All right? So they're saying it's an unfounded motion because they've not even addressed any of the issues from that judgment. Motions to reconsider are prohibited except by express permission of the court, which will only be granted upon showing of compelling circumstances, which is a general practice rule. Motions for reconsideration play a very limited role in civil practice and should be approached cautiously and used sparingly. Again, another civil practice rule. Granting a motion for reconsider is in the court's discretion and is subject to review for abuse of discretion. And again, some cases here. Rule 115.11 does not specify grounds for which a motion to reconsider should be granted, but the advisory committee comments indicate that that a court is likely to reconsider its earlier decision when it is palpably wrong in some respect. A court is not to contemplate new argument or evidence in deciding a motion for reconsideration. And again, case law. Motions for reconsideration are not opportunities for presentation of facts or arguments. Okay? So they've done the introduction. They've given the legal standard. Okay, here's our arguments. Defendants may not rely on facts or arguments which were not presented in their initial summary judgment findings. And again, if you remember, when we read this out at the time, I said I did not feel that presenting new evidence was reason for reconsideration. If it's not before the court, it can't be used. The judge can only use evidence that is before the court. So you can't say to the judge, hey, we need you to reconsider your decision because we didn't put evidence in. If you didn't put the evidence in at the time, then, or you didn't plead your argument well, that's on you. That's not on the judge, first of all. Okay? All right. And we saw it in the Bruce Lerman case, what happens when you have the wrong type of lawyer working for you. So Bruce Lerman had his appeal for his civil action just recently, and he used a criminal lawyer because he couldn't afford a civil barrister. He couldn't afford a barrister in that specialized in civil law. And let me just tell you, it showed. If you have a lawyer that is not a specialist in that field, then you are in big trouble. Jennifer Moore should have known better. Well, she should know whether or not her client's a plaintiff or a defendant. Okay, so here we go. On the 18th of August, 2025, defendants filed a notice of motion and motion for reconsideration, a memorandum in support of defendants' motion for reconsideration, and a declaration of attorney Jennifer Moore. Defendants' December 9, 2024 motion for summary judgment contained the following arguments. Plaintiff's defamation claims must be dismissed as defendants' statements were privileged. Defendants' statements were either true opinion about individuals and organisation, not part of this lawsuit, or non-reputational. Plaintiff's tortious interference claim and intentional interference with prospective advantage claims must be dismissed because plaintiff's conduct was fully protected under the First Amendment and justified under the refusal to deal doctrine. Plaintiff's negligence per se claim made pursuant to Minnesota Statute 609.765 must be dismissed because the statute has been deemed unconstitutional. The court in its June 23, 2025 order addressed the arguments as follows. Defamation. The court found that the first prong of defamation has been met as communications to third parties. The second prong of defamation was found to be a question for the jury. The court carefully reviewed all of the plaintiff's videos and captions and does not find that they are all rooted in opinion. While Ms. Paulson occasionally claims in her posts, so these are direct quotes from the judgment. So you got paragraph 32. While Ms. Paulson occasionally claims in her posts that the information provided in her posts are her opinion, she usually follows these posts with hashtags referring to trafficking, human trafficking, sex trafficking, cults, forced labor. These posts must be construed as a whole. When looking at each post as a whole, a reasonable jury could find that Ms. Paulson acted with actual malice. The third prong was determined to have a genuine fact issue for for the jury as to whether allegations could harm the plaintiff's reputation in the community. Thank you, Gracie Lee. Great. I don't know why Miranda suddenly stopped TikTok. Maybe there's a lot of stuff happening behind the scenes. Do I think Robert Shin is shady? It is my opinion that there is probably something shady going on, but it would be in relation to the church more so than the. This is just my opinion. It's more than likely to do with the church, and more so than anything else, is my opinion. But yeah, as I said, that's just my view, my opinion. I'm allowed to be wrong. I'm allowed to have that opinion. And I think it's also would be to do with the immigration. There'd be immigration or tax. I don't know that it'd be anything else, to be honest and fair. But hey, could be wrong. Been wrong before. So tortious interference of contract. The court found that plaintiffs testified that they had sponsorships or contracts. Ms. Paulson clearly knew of these contracts. Ms. Paulson knew of these contracts as her post referenced them. Ms. Paulson's alleged interference being justified or not is a question of fact. Plaintiffs have stated they suffered financial loss since the defendant's interference. Now, these are quotes straight from the judgment, by the way. Intentional interference with prospective advantage. The court found that a jury could find the plaintiff had reasonable expectation of economic relationship based on their previous contracts and follow accounts. Defendant knew about the plaintiff's economic expectations as she would post about ongoing or potential relationships plaintiffs had. With sponsors, a jury could reasonably find Ms. Paulson intentionally interfered with these potential contracts. A jury could conclude that it is reasonable, probably, that the plaintiffs would have realized further economic advantage on these contracts based again on their social media presence and history of earnings. And the plaintiffs have stated that they earn less money each year since the defendant's posting. Negligence per se. The court held that the current version of Minnesota Statute 609765 has been amended since the State versus Turner case and has not been held to be unconstitutional. A reasonable jury could find that plaintiffs are the type of persons intended to be protected by the statute and legislative intended to present this behaviour with this statute. The court further found that issues of material fact as to the justification of the plaintiff's reporting. Defendant's motion for reconsider addresses the following arguments. As a matter of law, defendant's statements are protected opinion. Plaintiff's implied defamation claim is legally deficient. Plaintiffs have not shown actual malice by clear and convincing evidence. Tortious interference claim failed because it's based on free speech. The court erred in allowing plaintiffs' negligence per se claim to proceed under Minnesota statute. None of these arguments include an analysis of an error by the court. Instead, each attempts to introduce facts and arguments not made at the motion for summary judgment. All facts and new arguments stated in the defendant's memorandum must be ignored, as a motion for reconsideration cannot introduce new facts or arguments. Interesting, isn't it? Defendant's arguments. The defendant's argument, her statements are protected opinion includes facts and arguments not contemplated in her motion for summary judgment. Defendant's motion for summary judgment begins its analysis of fact or opinion on page 61 of its memorandum in support of summary judgment. Defendant's entire analysis of this issue is 4 paragraphs. The only statement regarding opinion are statements the defendant made which are purportedly opinion and not fact. The word opinion is mentioned 20 times in her memorandum. There is no case law outlining fact versus opinion. As no new facts or arguments are allowed in a motion for reconsideration, it would be improper to address the new arguments submitted in the defendant's motion for reconsideration. That is a classic, although the word opinion is mentioned 20 times. Even if the court were to consider the new arguments and case law brought up by the defendants in their motion for reconsideration, would still fail as their argument proves that there are genuine issues of material fact for the jury to determine. Hello, Bella. Hello, Aussie boy. Taking defendant's own newly introduced case law in the McKee versus Lorien case, purportedly to determine if a statement is fact or opinion, requires a 4-step test: precision and the specificity of the statement, whether it is objectively verifiable, its social and literary context, the broader public context in which it is made. Each of these prongs require a fact finder to weigh evidence, as shown by defendant's own analysis in each of her memorandum. On a summary judgment motion, a court may not weigh the evidence or make factual determinations. As defendants have not relied upon any argument made in their original summary judgment motion, have not addressed any failure by the court in their determination regarding statements of opinion, and are asking the court to weigh evidence at the summary judgment stage, the court must deny defendant's motion for reconsideration based upon defendant's allegation of protected opinion. That is a good point, because she never actually put in her summary judgment any of these arguments. And look, the other thing is some people step away from social media for various reasons. I mean, the timing might be related to that. I mean, my daughter's taken a social media break. She disappeared from social media because she wanted to spend time doing something else. Now she's 25. But, it could be coincidental, but I wouldn't, maybe they were getting lots of harassment online and just said, let's take a step away for a while until this settles down. I don't know. But yeah, so that's a really good point, is that now that she's used opinion 20 times in this motion for reconsideration and all this other stuff. So they're saying you cannot input new arguments in. Just if I posted you, I have to admit it's 12:39 and I actually just it's a Saturday and it's PM, it's around lunchtime. I actually just got up out of bed. I had a shower and everything, went back to bed for a bit. So I just decided that I'd have a bit of a lie-in today. I'm just having a really lazy day. So I've actually got up out of bed to do this for you guys. I thought, oh, come on, I have to do it. I didn't, and I also had to get up out of bed because I didn't think you'd really want me to live streaming while I was in bed. That would have been interesting, wouldn't it? Okay. Defendants did not present any argument related to defamation by implication. Defendants in their motion for reconsideration state that the Jadwin versus Minneapolis Star Tribune Co. case prevents implication-based defamation. However, this argument was not addressed in defendant's motion for summary judgment, and it is unclear which of the plaintiff's claims defendant is addressing in this argument. As defendants wholly failed to make this argument in their original motion for summary judgment and have not stated which of the plaintiff's claims this applies to. The court must deny the defendant's motion for reconsideration based on defendant's allegation of defamation by implication. Now, don't forget, they have, I think, is it 14 days now to respond? Katie Joy's side has 14 days now to respond to this. We don't care if you're in bed with or thank you. All right. Defendant's argument plaintiff have failed to show actual malice by clear and convincing evidence is not appropriate for either a motion for summary judgment or a motion for reconsideration. Defendants have again failed to address any error by the court in their application of the law or an erroneous finding of fact. Instead, they introduced arguments they did not make in their motion of summary judgment and are asking the court to weigh disputed evidence on a motion for reconsideration of a summary judgment and find in their favour. This request is inappropriate on a motion for reconsideration. Plaintiffs have continually denied that they are public figures and that an actual malice standard applies to them in this lawsuit. One, plaintiffs did use actual malice in their own motion for summary judgment, claiming not that the standard is required, but that even if it was required, they have still met the burden. Plaintiffs continue to contend that they are not public figures. All right. So you've got one side saying that they're not public figures. You've got the other side saying that they are public figures. And remember that whether they are or not, because there's no agreement for that, that is what we call a finding of fact. And that has to actually be determined by the court. So the court actually has to determine, it's up to the court to decide now whether they are public figures or not. So that is another reason as to why it would need to go to the next stage, okay? Because there's no agreed facts. They've not agreed. I mean, then we get to the point whether she's a journalist, a blogger, social media, or whatever Katie Joy is. That also has to be determined by the court as to what she is. Once the court determines what she is, then they can take the next step. But anyway, all right. Defendant's statements that the plaintiffs have conceded they are public figures is an outright lie and unsupported by any statements and pleadings or findings made by plaintiffs. They've used the word lie. That is a very bold statement. Now they go on to say the court has not made any findings as to whether or not plaintiffs are public figures, and actual malice even applies to this lawsuit. So they've just said exactly what I just said, because the court's made no determination. If the court decides that they are public figures, then you have a higher standard. But if the court determined that they're not public figures, then you could then deem it there was malice. So the court's not even determined any of this. As there is still an outstanding legal issue as to whether actual malice applies in this case or not, dismissal or plaintiff's claims for failure to prove actual malice is inappropriate. Further, we are here on a motion for reconsideration, defendant's motion for summary judgment. Plaintiff is not required to prove anything by clear and convincing evidence in a response to a motion for summary judgment dismissing its claims. Defendant's assertion of clear and convincing evidence is based on a trial court standard. She has provided no case law that states on a motion for summary judgment the party opposing the motion must prove evidence by clear and convincing evidence. The court applied the following law with respect to its analysis of actual malice standard. A court deciding a summary judgment motion must not make fact findings or otherwise weigh evidence. The district court determines whether genuine factual issues exist. Actual malice is shown by proof of defendant's actual knowledge of falsity or reckless regard of the truth or falsity of his publication in Jadwin versus Minneapolis Star. And this is, I've always stated that I believed that if there was going to be malice, it would be a reckless disregard of the truth. Reckless disregard for the truth is a subjective standard, according to this. The court further found that given the statements on record, a reasonable jury could find that Miss Paulson acted with actual malice, as reckless disregard for the truth is a subjective standard. It is appropriate to submit this to a jury for a fact finding and inappropriate to determine at summary judgment stage. At the summary judgment stage, it is not proper for a court to weigh evidence in a matter which would amount to clear and convincing evidence. That is a matter which is properly sent to a jury as the body who weighs evidence. Summary judgment is reserved for those matters where there is no dispute or general material facts. The underlying facts as the defendant's actions as they apply to actual malice by defendant's own admissions are disputed in this lawsuit. So again, where there is, summary judgment is reserved for where there is no dispute of general material facts. And they're saying the malice issue is disputed. And the reason why it is disputed is this argument over public figures or not. And there's been the court's not determined that. And so they're saying it still has to go to the trial because the jury has to actually, or the court has to determine by what standard of malice. And then, as they said, the judge said in her judgment that a reasonable jury could look at what's been done and state that there could be malice. She didn't say they would find it or they wouldn't find it, but she said that there could be an argument as to malice, okay? Defendants have failed to address any error in the court's 23/2025 order, failed to make this argument in their original motion for summary judgment, and are requesting the court to weigh evidence on summary judgment. The court must deny defendant's motion for reconsideration based upon the defendant's claims. Plaintiff have failed to show actual malice by clear and convincing evidence. It's a very, So their arguments are you can't bring in new evidence in the motion for reconsideration, and you can't bring in new arguments either. So defendant's argument, the plaintiff's tortious interference claim fails and is protected free speech, was not contemplated in her original motion for summary judgment. Defendants have not argued what part of the court's order was with respect to the claim for tortious interference. Defendants further continue to assert new arguments which were not contemplated in their original motion for summary judgment at this stage. Hello, Koi. Defendant's original argument was that there was no evidence that the defendants contacted any organisation that contracts or might contract with the plaintiffs. Therefore, the claim must be dismissed. The court found that the defendants intentionally posted contents referencing her contacting multiple organisations, and Ms. Derrick testified that she is aware of the defendants contacting brands with whom she contracted. As defendants state no brands were contacted, and the plaintiffs state brands were contacted, there is a genuine issue of material fact with respect to this matter which makes summary judgment improper. Defendant does not make any mention of how or why the court's findings of facts or application of law of this case are erroneous. Defendants' initial arguments state that the plaintiffs do not claim defendants actually contacted third parties, but that they have called for a boycott. This is a blatantly false narrative. Plaintiffs' pleadings have absolutely asserted that defendants both contacted third parties and that she called for boycotts and instructed followers to contact third parties. Defendants in their motion for reconsideration admit that she publicly posted videos encouraging thousands of her viewers to stop supporting plaintiffs for the reasons outlined in the posts. Defendant's memorandum of law in support of its motion for reconsideration, page 17. The remainder of their reconsideration arguments rely on the claim that the defendants factually did not contact third parties, which is a currently disputed fact. As this fact is disputed, defendants cannot win on a summary judgment motion standard. Further, the cases and arguments relied upon were not presented in defendants' initial filings. Therefore, they cannot rely on those new legal theories to support their motions for reconsideration. Due to the defendant's failure to address these arguments in her original motion for summary judgment and the existence of genuine disputes of material fact, the court must dismiss defendant's motion for reconsideration based on the argument of tortious interference was free speech. Again, very interesting. It's interesting how she says she's used the word lie and false narrative. And don't forget, Katie herself has changed her story, whether she contacted or whether she posted stuff, called for a boycott, called her followers to sing Kumbaya or jumped up and down. What does internet do your thing imply? What would a reasonable person on a jury believe if that you saw a post that says internet do your thing? What are you doing? All right. What are your thoughts on this document? I'm thinking this is quite a well-written bit of work here. Defendant's arguments, plaintiff negligence claim is legally deficient, was not contemplated in her original motion for summary judgment. Defendant's entire summary judgment amendment on negligence per se is as follows. Minnesota Statute 609-765 provides for criminal penalties for defamation, and presumably defendants contend that a violation of that statute confers liability pursuant to a theory of negligence per se. However, the criminal defamation statute was declared unconstitutional in State v. Turner and cannot be used to confer criminal liability in the state of Minnesota. Defendants did not address the amended law, which overturned the finding in State v. Turner in their motion for summary judgment. Therefore, they may not bring additional arguments which were available at the initial filing of the motion. Defendants have also failed to identify how the court's application of law was improper. Further, defendants argue that no court has held the amended law unconstitutional. Due to defendants' own concessions, plaintiffs are entitled to proceed on this claim as the current statute has not been found to be unconstitutional. Defendant's motion for reconsideration based upon alleged unconstitutionality must be denied as a matter of law. Ruth says her arrogance shines through. Wow, it's interesting that they've taken each one of her arguments and has squashed it. And they keep coming back, and I'd like to know how many times they've reiterated the sentence, cannot bring any new arguments in or any new evidence. Defendants have not used the correct procedure mechanism for any alleged discovery violations. Again, defendants have wholly failed to address where the court has erred in its orders for summary judgment. The court addressed the mention of discovery disputes by referring the parties to bring a motion for those discovery disputes. Defendants have not provided any legal authority which allows for discovery disputes to be determined via summary judgment. And if you remember rightly, that was what the court ordered, that they had to bring any discovery disputes via motion. Defendants have acted in bad faith in bringing this unfounded motion for reconsideration, and the plaintiffs are entitled to costs and attorney fees in responding to the same. Wow. So a trial court may award attorney fees if the party or attorney acted in bad faith, asserted a claim or defence that is frivolous and that is costly to the other party, asserted on unfounded positions solely to delay the ordinary course of the proceedings or to harass or committed a fraud upon the court under Minnesota statute. Defendants have brought this motion for reconsiderations for reasons wholly outside of Rule 115 of the Minnesota Rules of General Practice. Each and every argument made by defendants fails to address in a way in which the court erred in their reasoning, analysis, application of law, and application of fact. Defendants' entire memorandum instead brings up new arguments which they did not contemplate in their initial motion filings and asks the court to weigh evidence which is disputed. As defendants have used this motion for reconsideration to re-argue their motion for summary judgment and include new facts, arguments, legal authority, they have brought this motion in bad faith and frivolously cost plaintiffs additional attorney fees as well as wasted court time. As such, plaintiffs respectfully request attorney fees and motion response costs be awarded to plaintiffs for their defence of this unfounded motion. Hello, Michelle. Amber clearly knows how to state the law and stays on topic. Her response and correspondence have always remained extremely professional. And Laura says, Amber should charge KJ double for having to read Jennifer's filings. LOL, I know this is not how it's done. I think we should be able to ask for I think we should put in the claim for having to read the filings, hey? So here's the conclusion. Defendants have improperly brought this motion to reconsider, addressing zero concerns which the court may reconsider, but instead costing plaintiffs money and wasting court's time with what is essentially a second summary judgment motion. Defendants have not pointed out to any misapplications of law, disregard for facts, nor any other error by the court. This is not a single statement that the court erred on in their order. Therefore, defendant's motion to reconsider should be dismissed in its entirety, and the plaintiff should be awarded its costs and attorney fees incurred in responding to this procedurally unsubstantiated motion. And so that's Steiner said. The other side acknowledges that sanctions may be awarded should this pleading be found in violation. So she's done two lots there. So that's that. So that's her motion for reconsideration. So then we've got her affidavit here. Again, her affidavit is somewhat a lot shorter. So this is an affidavit made in support of the reconsideration. Okay. So she's got here, and she's attached Exhibit A, which is the Finn versus Walsall State Bank. Again. So this is all that she's filed is this case, okay? I just find it really interesting how it's laid out, and it's so much different to how it is in now said, this opinion will be unpublished and may not be cited except as provided by Minnesota statutes. So where it's unpublished, okay, unless, yeah, you can get, we have unreported cases and reported cases, but usually, quite often though, it's only really the judgments that you can use as a quote, except as provided by Minnesota statutes. Okay, so you can't really quote some of these. But you can definitely read it for arguments, and so that's that one. Okay, so then they've got the defendant's motion for reconsideration is denied. Defendant shall pay plaintiff's costs. Plaintiff shall submit an affidavit so that's what she wants. So remember, this is what she's filed as to what they want. They filed the order that they want, so they're hoping that the judge will stamp this one. Okay, this is what they would like. Proposed. See, they've put in proposed order. So that's where we are with the current filings. Now, what are your thoughts on all of this? Out of interest, what are the thoughts? Do you have any thoughts on it? Yeah. I just want to look at this. This is a Miss Ball's post, okay? This is from Justin Baldini. Oh, no. I'm just going to share this. Hang on. From her Reddit. Oh, look, she's got, I think, is it 14 days or 21 days to respond? So this is a screenshot that Miss Balls is putting from this Reddit group. But she says here, I don't know if Perez will win or not, but I've been sued, gone to court, fought having not to give up sources, only to have a judge force me to provide a list of sources to them who are listed as privileged. Then to be told I have to turn over communications in court. I really hope Perez is more successful than me. So it's very interesting. Yes, the judge said I was a journalist. The source list was sent over as attorney's eyes only, so the defendant never got to see it, and I didn't have to give up any communications. She was never deemed a journalist. I've never seen anywhere where she has been listed as a journalist in this case, but just saying. So that's where we are. I don't believe she did. I mean, as I said, asking the judge to reconsider is like going to a parent and asking them to change their mind on the decision that they've made and pleading your case to them. I don't know what your parents were like, but my parents often didn't change their mind. So she's going to the judge and saying that you were wrong. And this is why you're wrong. But as I said, they put in there, in her motion, they put in there that she had been raided. That has no relevance. That has no relevance to the summary judgment because because it can't go. You can file a motion to add more evidence in to say that things have come to light, but I think that is at the trial stage. When you get to the trial stage, you say, I want this evidence, want to put this evidence in, and you can have arguments over relevant evidence because sometimes more information is sought out. But often, and again, this is often the case in Australia, you can't bring in civil judgments or civil matters into a criminal, and you can't do criminal into a civil. Very rare does that happen, and usually you have to ask for the judge to give permission to file that. So I just don't know. I'm not sure. I mean, it's very well. What Amber has written is very is very good, very succinct, and has played it well. And she's gone through and she's looked at the judgment. She's looked at. You do have questions about the timeline. Well, we don't have a full timeline yet because Katie's still trying to get a summary judgment. So remember, some items were she got and some she didn't. Now the ones that she got were where there was clear evidence of statement of fact. Robert, yes. That would be an argument for the court, Laura. He could be considered now, but when he filed the lawsuit, the documentary wasn't out. You see, so there would be a whole this is where the arguments. This is where the arguments would all come in, because they would have this big argument and say, well, when he filed this, he wasn't. And a lot of the defamation actually happened before the documentary came out. The alleged defamation before it all came out. So then you've got Not to mention there've been raids and no arrests. That's right. But what do the raids? What do the raids have to do with defamation though? Oh, here, you see that she paid $100 was paid by Katie Joy for that motion. By the way, 18th of the 8th. So which part of her defamation, her alleged defamation, does that come under? Is that the waterboarding, the human trafficking, the sex trafficking? So just this, because otherwise she's grasping at straws and trying to put it all in one big basket. So, and we don't know what the raids have been for. We don't know what they raided it for. As I said, I think it might be immigration issues, but that doesn't mean just because he got the immigration issues doesn't mean he's guilty or innocent of all the others either. But we don't know. I'm ready for this to go to court and for KJ to lose her Bentley. Yeah. The raids may have nothing to do with Katie's case. That's right. And it could be totally unrelated. How do you know that they were raiding because of something to do with Robert Shin? Wasn't the brother-in-law there? It could have had something to do with the brother-in-law. You don't know. So as I said, we don't know. We don't know what the raids were for. We have no idea what's happening there. But what we do know has happened is that there have been a whole pile of facts where a whole pile of things have been said where there's been no evidence, opinion or fact. I'm not sure. We know that's been spread across the internet. We know for a fact that 7M as the entity does not exist anymore. And we know that they've all lost money and endorsements. Now, whether that is because of stuff that Katie Joy has said, I guess the jury's out on that. However, dance company versus management company is the biggest thing. So, I don't. Well, I mean, again, he might be just sitting back because if let's just say 7M win attorney fees, I would imagine Amber would be a top. I reckon she'd be top. Let's see if she's got her fees listed on here. I'd be interested to see how much she would charge. And in fact, she must be doing all right because she's got another lawyer working for her now. So she's expanded her practice. She's got a new one. She's an associate attorney. And she's a new graduate. She focuses on civil litigation. So again, another civil expert. She serves on the council. This chick serves on the council as on the sports and entertainment section of the Minnesota State Bar Association. So she knows about she would know about entertainment law, which this would fall under. So there you go, and that's Amber. But yeah, I'm interested to see how much she would charge. I reckon she'd be nearly a 400. Should nearly be a $400 an hour attorney. Look, I know the top barristers in Australia, it's $1,500 for a day in court per day. So, because she was with a law firm and then's gone out on her own. And she only practices in one area. She just does civil. So that means that she knows what she's talking about, I guess, would be the way to do it. Excuse me. Yes, Sister Wives is starting, isn't it? Can they still do should it be called Sister Wives? Because none of them are together now, are they? Like they don't even really get together very much now. So apparently in Minnesota, they say they charge between 148 and 524 per hour, with the average being 305 per hour. So she would possibly be at the top end of she'd be about 500. I said I think she's about $500 an hour. She'd have to be around that, because I reckon she would be. Yes, AJ Lee returns. That's good. And I think isn't KJ's lawyer about 350 or something? So, I mean, I know why they're probably trying to get legal fees, because remember, they don't have a lot of, they may not have a work. Do you think Todd will go? I don't know. So, Aussie boy, I'm thinking he's going to hold out and see what happens with this 7M case, because if 7M was, let's just say 7M and the Derricks, let's just say they all win. Let's just say they win, and she owes them. She could essentially be bankrupt, and then what's the point of going after her for something when she's got nothing? But don't forget, I'd imagine Amber would have charged around $5,000 for this filing between research and talking with client and other fees. Yeah, it probably would be. The only good thing is there hasn't been a court appearance, because, as I said, that's like flat. That is often just a flat rate. It might be $500 for the day or whatever, because like they can't do, if they're just sitting around. I don't know how it works in Australia, but often I wonder how she's going to cash in on. It's definitely going to be. It's going to be interesting to see what happens here. Thank you. Yeah, but and the thing is, and if she gets, I was going to say, she could be found. She could be found to have defamed only one of the parties and not all of the parties, or one of the parties, like let's just say 7M, might be deemed to be a public figure, and the other parties aren't deemed to be public figures. So there could be partial claims, and I mean that will still be. It will then come down to compensation, of course, but she might have to pay hundreds of thousands of dollars. So then what? $3.50 an hour, submits her own documents in her own words. Yes. Well, even the way that the documents are laid out are completely different between the two. And so you've got to wonder whether, it is being done, they're done properly. And here's the thing, if she is writing her own documents, then why on earth is she bothered with a lawyer? She could have saved herself a whole lot of money, because we know she's a law expert, if she just did it all herself. And courts often are actually a little bit nicer to self sometimes, because they have to make sure that justice, they have to adhere to fair justice, so they have to make sure. And that happened in the Bruce Lerman appeal, when you had a criminal lawyer up against the two top defamation barristers in Australia. The judges had to talk her through and explain things, and gave her a lot more leniency, because she's not a civil lawyer. So, and some people said that was unfair, but for them to be able to make their decision, they need to make sure that fair justice is adhered to. She totally do. And I mean, there were still questions early on about her, some of the stuff that she said about the documentary, and how she claimed credit for all of that documentary. That could form parts of the compensation stuff. Judges don't like it when you don't have a lawyer. They don't, but they also understand. You think she's broke or close to it? Definitely will be interesting. And don't forget, if she was to lose, she'll be playing the sick child card very, very hard. Now look at when she referred to herself as the plaintiff. Big old error on her part. No errors by the judge. No, yes. You'll see. I want to know who wrote that. I mean, that's a big mistake to make. Although, as I said, if you're confused as to who's the plaintiff and who's the defendant, Katie's confused as well. Katie's side's confused as well. So can't feel that bad. Yeah, man, that's good. Anyway. Yeah, so I hope you're all doing really well. I've been on the 17 weeks I've been on this medical trial. I've lost 10 kilos. I don't know what that is in pounds or whatever, stones or whatever it is. It is 22 pounds, by the way, 22 pounds. I haven't lost. It's funny. It's not coming off the tummy, so I reckon it's coming off everywhere else because people are saying to me my face is looking thinner, or this and that and that. And I've still got some nausea. I've also been working with a dietitian, and I'm into week 3 of working with a personal trainer just to try and get that move. Get that weight moving again. So. You're making some positive changes. My last blood test actually said my cholesterol was on the low side, which it had been high. So the changes I'm making are obviously working. So well, Katie blocked me on TikTok ages ago because she said that I was a horrible stalker or something. I don't care. Look, I don't check Instagram. I sort of just can't be bothered with her anymore. And it's just too much. I'm trying to get on. I actually did this. I actually went for a walk there a couple of weeks ago and filmed it. It's still sitting on my phone. I haven't edited it yet, so I'm going to put that up as well. Look, I'm trying to get on a little bit more. I just have lost this year. I've just found I've just hit the stage of I can't be bothered. I just can't be bothered. Things are just there's so many things that are just too hard. You think I look great? Thank you. I have gone down. I think 2 dress sizes. So it is coming. And I'm just doing a lot of strength training with the trainer because got to just make sure that the muscles, I'm building the muscle up. It's just what I needed. Every 4 weeks I go get all my measurements done and everything. And the waist is, I've lost, I think 6 centimeters around my waist. So it is coming. It's just very slow. But the one thing that I have, the dietitian has got me doing is, I have a tendency not to eat time. Sometimes I forget to eat. And so I have to have, he would prefer that I have meal replacement shakes rather than skip meals. So I do have meal replacement shakes. And so it may mean that I have 2 meal replacement shakes and 1 meal, or so if I have a big meal, I might then have meal replacement shakes. So I had bacon and eggs this morning. So I'll go and have a shake, which will be my lunch, and I'll see how I feel for dinner. But it really depends because I've still got nausea. I still suffer from nausea as a side effect from the trial. So sometimes I just can't eat, or the thought of eating or this food sets me off. So meal replacement shakes at least are still giving me the nutrients that I need. So yeah, my hair is probably due for a cut. It's starting to split at the end, so it probably needs a little bit of a trim too. So and I've discovered that I can go live on TikTok as well. So that was a good thing. I'm probably going to go live on that as well. I'm hoping to just do a TikTok live and a Facebook live at some point in time. I mean, not Facebook live, YouTube live, like this. So that's when you feel good about yourself, isn't it? The changing clothing sizes are really good. Though I had a dress I wanted to wear for my 50th, for my parents' 50th wedding anniversary, and although it fitted me, it was snug, and I was very self-conscious about my stomach. So I decided that I probably, rather than wear it and be self-conscious, I wore something different. But I've got it there. My goal is to look hot and amazing with a less than you know, even if it's got a little bit of a tummy. But it was just standing out. Oh, thank you. Well, nothing worse than having your card declined. Even that's why I still prefer to use cash, because at least I know that I've got it. But I hate that. I hate that. That wait while you're waiting for it to say approved. Yeah. I think I'm starting to get a little bit more energy. Although, as I said, I didn't get up until I did this live. I only got up out of bed over an hour ago, but I did have a shower. I did get up and have a shower, went back to bed for a bit, and I did go downstairs to have some breakfast. So I have been up and down, but I just kept going back to bed. But Saturday, oh, thank you. Well, look, sometimes we do have to be selfish and we. So that's why I don't feel guilty that if I'm home on a Saturday that I spend a lot of it in bed looking after myself. I've got really into those verticals. Have you seen those verticals? Those vertical short films? I'm really into those at the moment. I've seen every time there's a new one, I'm watching it. In fact, my partner's got into them as well. And he says, I've just seen this new vertical. I said, oh, yeah, I've seen that one. And, you know, and it just whisks me away. Just, you know, if I'm having a really tough day, those verticals, particularly where there's a handsome guy that saves the day, you know, that stereotype, saves the damsel in distress. You can just take your mind away and just imagine what it would be like to have that guy come and save you. And as an Australian, it's great. There are a couple of Australians that do them as well. And so every now and then you'll pick up an Australian accent. I have to say though, some of the scripts and storylines are very flimsy and they're very annoying. I have been known to yell at the female lead a couple of times, and often if there's one done, I've just started to watch another one, and I've already seen a similar one. The storyline, it can be like a similar story, nearly identical, but they change bits of it. But I do like the ones where they're reborn, so they die and then they're reborn and they change the course of history and they get revenge on everybody. Yeah. You feel like and unless I've got something to do on the Saturday, then I will. Like if I've got appointments and stuff, I get up. But if I don't have to get up, I don't get up. And that's where that's where the problem lies. If I don't have to get up, I don't like getting up. And then you know, I go, gee, I should have done this and this and this and this and this. But anyway. Drama Box is one. Hello, Plan to Create Drama Box. There's Real Short. Real Short's probably the biggest one. I've got about 6 of them that I watch. Yeah, Drama Box is a good one. I don't pay for any of them either. I do. Yeah, I mean, some of the writing is pretty horrible, I have to say. There's a there's a whole pile of whole lot of apps. You get hooked on those too? Yeah, Real Short. There's Real Short, Net Short, Mini Shorts. There is Good Short. And it's interesting though, and that the villains are often the same actors. And I saw one person who's played lots of villains, and she played the lead, and I couldn't get into it because I couldn't accept the fact that she was a lead. Did you know Plan to Create? Nick Westaway, who was on Home and Away, is one of the lead actors on some of these. Yeah. So I download, but there is a website where if you're lucky they bootleg. I shouldn't say about bootlegging, but is that what that's called? When they put them up, they record them and they bootleg it. You watch on TikTok because I'm always supposed to. I'll send you. So if you go to Daily Motion and put the title in, often you'll find it in Daily Motion that's been bootlegged. I shouldn't tell you all this. There's one I'm waiting for it to hit Daily Motion now because I don't know that I can wait until tomorrow. And so some of the male actors, particularly, like there's a whole vertical convention now, and some of the male actors are going on there. And there is also AI ones as well. So sometimes there's verticals with AI generated ones, and they're very interesting because you can tell they're AI. Yeah, have a look there. Look at the title. Look for the title in Daily Motion, and you'll find it. I actually have bookmarked Daily Motion. My iPad has a Daily Motion bookmark because that's where I that's where I go all the time. Yeah. And then some will trick you as well. So you've got to be really aware that some will have the title you're looking for, but it's not the movie you're looking for. And then sometimes you'll find one that isn't what you were looking for, but you'll find one that's just as good. Like the one I'm looking for at the moment is Blood and Bones of the Slain Daughter. Now they're saying it was only released it was only released about 12 hours ago, and they've got things that were uploaded a week ago, so I already know that they are not the movie. So I'll have to wait. I mean, I guess I could do a review of my favorite verticals because there are some that I just love and watch. So there are some that are very violent, have a lot of violence in them, which I don't like. But when you remember that a lot of them come out of China or Asia, the storyline's different. It really annoys me. I like to watch funny pets and babies on set and when overwhelmed. It does annoy me though when all of these people go to have their babies and all the guys are left outside pacing up and down, because I know in Australia if you wanted to have 5 or 6 people in your, you can, but no, they're all sitting out there. The other thing is that there's a married couple that also works. They also act together and they act on verticals, and it's very interesting watching that dynamic because there's one where she plays the ex-wife of the male lead, and that's actually her husband in real life. There's another one, and sometimes she plays the enemy. So yeah, it's really funny when you see these dynamics. But anyway, that's just a segue. But Real Shorts had some tearjerkers of recent days where I've just bawled my eyes out. I probably needed to have a good cry. So if I want a good cry, there's some to watch. But there's some that I will watch over again, and then some I won't. So And I've noticed also Plan to Create, some of the verticals are also starting to appear on YouTube in their entirety. So you can sometimes get that there. So, but yeah, that's just a whole thing. And they film them like soapies. So they're filmed like a soap opera. Well, some of them are a soap opera, but yeah. But there's a few Australian actors that are in them now that have made it. And for those, for when the time when there was the actors strike, the verticals became very popular for acting, so it's kept people in jobs. But some of the vertical people now are traveling. I think there was one that was filmed in Italy. They're filming some in China, so they get to travel the world. I would like to watch the nursery nurse skits as well. I have to have a look at that. So if we get back to the court filings, I think we're discovering that probably Miss Jennifer's out of her depth a little bit, going up against a civil expert. It's, as I said, when you are specialist in a certain thing of law, that's why a lot of them have specialties, so that they are really good at what they do. And I mean, I've watched the two top defamation lawyers in Australia go up against each other. Often that their opponents, they're not always on the same side, and that you cannot pick which one's going to win and which one's going to, it's fairly, sometimes they win, sometimes they lose. It's just, but when they team up together, you like the ones with the toddler mitts and your siblings. Yeah. Yeah, so if you get the two top defamation lawyers in Australia on the same side, you're almost guaranteed. It's almost interesting. So that appeal was interesting. The other thing is, I think Ben Roberts-Smith had lost an appeal in the High Court too. So not everything, it's interesting. What was interesting about the appeal for Bruce Lemon is that Channel 10 was actually challenging one of the judge's findings, right? But it had no relation to, it was in relation to consent. And that I found that to be very interesting. So they thought the judge should have made a finding about that. So I'm just going to check. This is the ABC's report of it, and look, I have to say, and they said that Miss Burrows ended up going against two of the country's most accomplished defamation specialists. Okay, now she's a criminal lawyer Miss Burrows is a criminal lawyer. So if, for example, if Matthew Collins or Dr. Collins and Sue Chrysanthi SC was going to do a criminal case and Miss Burrows was their opposition, they would probably be out of their depth. They may be able to struggle through. But they launched the opportunity to appeal their own contentions with the decision. So Network 10 urged the court to find Bruce Lerman did know, in fact, he did not have consent based on how intoxicated Miss Higgins was. So that was one of their things. And then Miss Chrysanthi also sought to reverse Justice Lee's decision to dismiss Lisa Wilkinson's qualified privilege defense. She argued journalists acted reasonably. And then so they had contentions with Justice Lee's decisions on those points. And this is Zali Burrows. So yeah, this lady was completely out of her depth in the appeal. So we don't do reconsiderations. So this was an appeal in front of 3 judges, okay? So when you do an appeal in Australia, in an Australian court, it goes, so if you appeal in the magistrate's court, it goes to the county court, then it goes to the Supreme Court, then it goes to the federal court, then it can go to the High Court. That's the chain of the courts. And then up until then there was the Privy Council, but we don't have the Privy Council. We're no longer part of that. Section 74 of the Constitution established the High Court as the final court of appeal in Australia, but also the means for appeal to the Queen in Council, the Privy Court, on certain matters, but it doesn't happen. 1986 was when the Privy Council from the state courts was removed. So yeah, so we don't have the Privy Council anymore, but the High Court is as high as you can go. And I think there's still the Privy Council now. Now, who's in the Privy Council now? I think it consists of, I think Prince Henry got taken off. I think Prince Andrew, there was talk about him being, I think. Okay, so let's look at the full members. So the members of Privy Council are members for life. They've just had some more join. Let's have a look who's on the Privy Council. So this only is relevant in the UK. There's 774 members of the Privy Council, by the way. It's a lot. Look at this little segue we've got to, hey? Just seeing if he's here. Philip. I think Prince Philip was on there too, but he's surely and probably come off now. That's what that would be. Oh, wow. The Queen's still on there, by the way. So they've got to update this because it'd be the King now. Queen. I'm just trying to think. The Wales, I'm just trying to think who they are. Wales, there you go. HRH, the Prince of Wales, is on there. I thought I thought, anyway, fortunately, we don't have to deal with the Privy Council, but there's 774 members of the Privy Council, particularly in the UK. So you're there for life. So anyway, all right. So based on that, I'm going to probably head off now, and we'll call that a wrap. We'll wrap that up now, and yeah, I'll go and do my next thing for the day. It's Father's Day in Australia tomorrow, so I'll say happy Father's Day to all the fathers that are watching. Yeah, so Father's Day's tomorrow in Australia. Still haven't worked out what I'm getting my dad yet, so it'll probably be a quick trip down to the shops. I don't know what I'm going to get him still. I don't know. It would have been nice if his football team had won last night, and then I could have given him that, but it's not going to happen. So on that note, I'm going to say thank you for watching, and I'll catch you again next time. And hopefully I won't be so long before I come back and be live again. All right, thank you very much, and I will catch you next time. Bye for now.